turn to Evan Wolfson, Executive Director of Freedom to Marry, and New York Attorney General Alex Schneiderman. Thank you both for joining me. Evan, I want to start with you first. I thought one of the craziest things to come out of this entire series of oral arguments was the notion that somehow gay marriage is this newfangled thing akin to cell phones. Now, you may argue that the legalization of gay marriage is relatively new, but the idea of two people wanting to join themselves in holy matrimony because they're in love with each other is old as time. What did you make of that?
Well, I think what you just said is exactly right, and I think we should put aside the words gay marriage forever. We're not talking about gay marriage. We're talking about the freedom to marry, something the Supreme Court has recognized in at least 14 cases as something very important. And Justice Thurgood Marshall said in one of those cases, though the case of Loving versus Virginia about interracial marriage may have arisen in the race context, the freedom to marry is important to all people. What gay people are seeking here is the same freedom to marry as other loving and committed couples share in, and we're saying, that there is no good reason for excluding gay couples from the freedom to marry. And as in the excerpts you played from the court, Justice Kagan and others asked questions, and the attorneys on the anti-gay side were unable to come up with a good reason. And that's exactly what court after court and now state after state have found.
Eric, that's a great point that Evan brings up, which is that those who are in support of Proposition 8 and against marriage equality have now found themselves painted into this weird corner where they have to make the case that gay people getting married is somehow harmful to the institution of marriage or heterosexual couples, which seems to be a losing prescription, is it not?
Yeah, I think I agree with Evan, and I find the argument that this is about something new. It's not about something new. Equal justice under law has been the founding principle of the United States for a long time, and the evolution of American law, because our Constitution is a growing document, which I think everyone except Justice Scalia seems to get, although he was, as was pointed out, happy to find a new twist to the Second Amendment contradicting hundreds of years of jurisprudence. We only evolve in one direction. We evolve towards greater equality. We evolve towards greater inclusion. And I think the analogy to Loving v. Virginia is right on point. I mean, in 1997, 16 states had bans on interracial marriage. Supreme Court just managed to come back to the reinvigoration of our principles of equal justice under law and due process and open the door a little bit wider, and that's all that we're seeking here. There is no argument. They hadn't. When we were debating marriage equality in New York a few years ago, there were a lot of arguments made about its effect on religious institutions, a lot of other hypotheticals. We have enough states now where we have same-sex marriages to know they don't create problems for religious institutions. They don't create problems for opposite-sex marriages. They were down to this argument that the state has an interest in procreation that somehow will be damaged. Well, that argument, there was literally laughter in the court during that part of the argument. So I think we're at the point where either in this case or if they do duck it and just uphold the law in California, allow California to go forward with same-sex marriage but not provide a broader ruling, the Loving v. Virginia moment is coming for LGBT couples all across America. If it's not now, it's very soon. The other side is out of arguments.
Evan, I want to follow on that, because if, as Jonathan suggests, there is an off-ramp that the Supreme Court takes, what does that do to momentum in terms of marriage equality, the activist community, the gay rights community? I mean, is that seen as a defeat? Does that stoke the fire? What's your read?
Well, look, every delay, every day that couples are denied the freedom to marry is real harm to those couples. It is an insult to their commitment and love. It means that parents will die without being able to dance at their kids' weddings. It means kids are growing up, as Justice Kennedy acknowledged, without the stability and security that marriage brings to many, many families. But in terms of the momentum, the very same freedom to marry strategy that has brought us to this moment, with 58% of the American people now supporting the freedom to marry, 81% of young people, 62% evangelical Christians under the age of 32, all supporting the freedom to marry. That very same freedom to marry strategy that has brought us to this moment will bring us to the freedom to marry nationwide, whether in June when the Supreme Court rules or in the next round. As Justice Ginsburg pointed out, the Supreme Court got interracial marriage wrong before they got it right. We're going to keep pushing, keep engaging, keep building support, and if not with these justices, then in the next round, if we do the work.
I will say this again and again until it is law of the land. The arc of history is long, but it bends towards justice. Those, of course, are not my words, but I think we can all agree on that this evening. Evan Wolfson.